Ladies and gentlemen, I welcome all to my channel. I am Razia Kali. Today, let us see about a hot topic. The central government has passed three criminal laws. One is known as Bharatiya Sureksha Sanhita, and the second one is Bharatiya Niyaya Sanhita, and the third one is Bharatiya Sakshiya Adhiniyam. The three acts were passed by the parliament in the year 2023, and it has been put into force from 1st July 2024. Now there are objections from advocates side and also from various sources, and now one of the case has been filed in the High Court of Madras, wherein the names they have challenged the names of the three acts, and they have stated that these names are not in English language, and these words are from Sanskrit or in Hindi. So and they have stated all this. They also stated that this under Article 348 of the Indian Constitution, the language of the acts and bills should be in English, and these words, Sanskrit words and Hindi words, are violative of this article provision, and so they have sought a direction from the High Court to struck down this law. So this is a position for which the central government Advocate General Mr. A.R. Sundaresan appeared and gave an explanation, saying that the act were passed only in English language, and for the names, the names are only nouns, and only English letters has been used to write down the names of these three acts. So all the three acts have been only English letter has been used, and all the three acts names have been written only in English letters. And so these are also English words, like what the central government advocate Mr. A.R. Sundaresan has submitted as explanation. And the court has directed the government to file a written statement, written submissions. So, and the case adjourned the case. Under these circumstances, we are discussing the what the law says. What is the law on this topic? And we are going to discuss that the laws with respect to these issues. Let us see one by one. The Article 348 of the Chapter 3 of the Indian Constitution speaks about the language of the Supreme Court, High Court, and also about the languages to be used for the acts and bills to be passed by the Parliament as well as the State Legislative Assembly. So the Act, the relevant provision, namely the Section 348 of the Act, reads as follows. Language to be used in Supreme Court and in the High Courts and for acts, bills, etc. Notwithstanding anything in the foregoing provisions of this part, until Parliament by law otherwise provides, all the proceedings in the Supreme Court and in every High Court, all the authorities' texts of all bills to be introduced or amendments thereto to be moved in either House of Parliament or in the House or either House of the Legislature of a state shall be in English language. So this provision, so actually this article 348 says that the language of the Supreme Court, the language to be used in the Supreme Court and the High Court shall be in English. In addition to that, all the bills to be introduced or amendments thereto to be moved in either House of the Parliament and in the Legislature of the state shall be in English language. So the language should be in English, like what the Article 348 of the Indian Constitution stipulates. Now the central government Solicitor General has replied that these words, namely the Bharatiya NagarikSureksha Sanhita, Bhartiya Niyaya Sanhita, Bhartiya Sakshiya Adhiniyam were English words, English letters that alone is used, and it is only a noun. So for a noun, the name is only nothing but a noun. And so and for that also only English letters has been used. Therefore, it is also in English, not some Sanskrit or Hindi, like what they has advanced an argument and explanation to the court. Now the question is whether such type of the court will accept this judgment, this type of explanation, or reject the recommendation. That further thing we have to wait and see the judgment. But regarding the my humble my opinion is that the central government may voluntarily may come forward and they may understand the difficulties of lawyers, judges, and officers, and even the policemen who will find it very difficult to pronounce these words, because this is not English words. It will be difficult for each and every one to pronounce and accommodate and practice and to implement these words because since it is not in English language. So, if for the purpose of convenience and for the welfare of the people, the government itself may come forward, and they may come forward and they may correct the name, and they may rewrite they may put some English words so that English simple words which is easy for each and every person for the day-to-day practice. If such type of approach is made by the government, then everyone will give due respect not only to the court but also give due respect to the government and to the present politicians. But instead of that, they have chosen to fight it out in the court of law, saying that they are right and they have used only the English language, like what they have submitted the document. But let us see what is the law, what is the constitution says about these things. So regarding this thing, the words, the 348 Article 348 1b says that the authoritative text of all bills and all bills shall be in English. So the wording uses authoritative text. Now we have to see what is the mean by text and what is mean by authoritative text. So the Act does not say that all the headings should be in English, or each and every words of the bill should be in English. The article 341b only says the authoritative text. So now what is mean by authoritative text? That is the main argument which will be in the final hearings of this case. So as far as the text is concerned, the simple meaning which is mentioned in the concise Oxford Dictionary, Little Dictionary says that noun text means noun, main part of the book or original document, like what it says. The advanced learners Oxford Dictionary says the meaning, gives the meaning as if text means main written or printed part of a book or text or page. So main written or printed part of a book or page, like what it was mentioned. In another dictionary, which is this is Oxford Encyclopedia Dictionary, the word text has been given a meaning that wording of anything written or printed. So it simply says that wordings. The text means wordings. Now, if it is so, dictionary. If it is so, the central government may advance an argument saying that this provision, this article only speaks about the main words, not the headings. It does not say that the heading should be in English, or each and every part of the act should be in English, and every sentence of the act should be in English, or every paras of the act should be in English, and each and every single word should be in English, like what the article of our constitution did not say. So it is not violative of our article, like what the federal government may advance the argument. Another point is that if you go through this article, the article not only says that the text should be in English. They have used the word authoritative text. Then now the question will arise: What is meant by authoritative text? So authoritative text means then the operative portion of the text, like what they may advance an argument. If such type of so they may central government, the predators or the advocate general may advance an argument saying that only the authoritative text alone was discussed in the Article 348 of the Constitution. So the Article 348 of the Constitution has speaks only about the authoritative text, not about each and every word, or not about each and every sentence, or not about each and every headings of the Act. So this article, as far as this article is, as far as the article is concerned, the authoritative text alone should be in English, like what the constitutional framers has expected from the legislative assembly. So, like what we have all the operative portion and authoritative text of all the three acts were in English words, like what they have put an advanced argument in the court. So, for those things, we have to wait and see what type of argument is advanced by our government and how they are going to reply. Like what we have to wait and see. So, this is the case position, which and. So, if the Solicitor General or the central government advance argument like this, there is a scope that they may succeed in their stand. In addition to that, they have put another important plea saying that the legislative Parliament has authority to decide the name, and they cannot, the court cannot interfere the authorities of the legislative Parliament, and the Parliament has every right to decide what type of name should be given to a particular act. And so the court cannot take the authorities of the Parliament, and the court may not decide what type of name should be fixed for a particular act. This type of argument is really a worthwhile argument. And so, as far as the Parliament is concerned, Parliament has every right and prerogative right to pass acts, bills, and they have every absolute right to decide what type of name should be given to a particular act. But when they are passing this act, our MPs, members of the Parliament, ought to have made their submission. They ought to have made their objections regarding these names, and they ought to have given a proper suggestion in the Parliament itself before passing this act to give a proper English word, so that this type of problem would not have arisen at this stage. But now we are in now we cannot, because the things which has gone is gone. We cannot speak about those things now for the convenience. Whether the court will decide whether the court will give a direction to the government to change the name, or the court will accept the arguments of the Advocate General. That further thing we have to wait and see. But there are scopes. There are scopes to the central government advocates, Solicitor General's argument saying that Parliament has absolute right, authority, prerogative rights to decide their name. And regarding this, if you go through the meaning of the text also, the act the article simply says that the authority text, the article speaks only about, deals only about the authority text. The article did not say the article of the Article 346 did not say that each and every word, or each and every sentence, and each and every paragraph, and each and every headings, and each and every words used in the heading should be in English. Like what they did not say in the this Article 348, and they simply said that the authority text, they speak only about the authority text, and they have given stipulation only about the authority text. So in that context, if they advance the argument, there is a lot of chances to the central government to succeed in their case. But even if you succeed, my humble request to the central government and to the East, please consider this as this is because this English, this Sanskrit word or Hindi word really gives difficulties not only to the advocate but also to the judges, officers, and to the police. And so you may directly come forward, and you may yourself correct the names in such a way that it is easy, comfortable, convenient to not only to the advocate but also to all, including police and public. So this is my humble request. So I request, through this video, I humbly request the central government to consider as a request and to come forward to change the name of the three acts in English. And you may simply you may put, instead of you can say written the same name, Indian Penal Code 2023, Indian Criminal Procedure Code 2023, and Indian Evidence Act 2023, so that will not give any sort of difficulty, problem, inconvenience to the public in general. So with this request, I conclude my speech. Thank you. Goodbye. Razia Kali.